Please, Your Lordship. For listing of a repetition, Lordship, against an order of Revenue Board, Lordship. Not fresh matter, Lordship. In this case, Lordship, we have filed to IA, Lordship, for stay and amendment of repetition, Lordship. Can we on 6th of February, Lordship?
All right. Yes.
Obliged.
Lord, eviction, my lord. Tomorrow, my lord. Eviction matter, my lord. Tomorrow, my lord. People are coming, my lord. They are
I will similar to that.
tomorrow.
You seem to have got a domain over eviction matters.
No, my lord, everyone must say.
All right, tomorrow.
Obliged.
Similar period.
Fresh matters, you have to file it first.
We have filed it.
File.
We have filed it.
All right,
Eviction matter.
all right.
Deep.
May I please, Your Lordship? I beg to mention for listing of repetition,
Oh,
3319/2025
for admission,
for admission.
admission. Let it come on 9th of February.
9th of February.
May I please, Your Lordship? I beg to mention one writ petition for listing for motion, Lordship. The matter pertains to freezing of an account by the bank authority, Lordship. There is some
Have it-
urgency.
Have it on Monday,
Monday. Okay, Lordship.
second.
Much obliged.
Look, item number 8, with the consent of the other side, some accommodation today, my lord. I am seeking apology. Lord, some difficulty today.
Item 8,
8, my lord.
on the request made by Mr. H.K. Das, matter stands deferred to be listed after 1 week.
My, fine,
Please, Your Lordship,
highly okay.
I'd like to mention a fresh matter for listing. Lordship, it pertains to election of a president of a cooperative society, no confidence motion. Only difficulty.
Have you filed it?
Yes, Lordship. Only difficulty was the election is supposed to be held on Monday. So I'm praying for tomorrow, Lordship. Obliged.
Huh? Oh. As per instructions received, counsel for petitioner submits if the writ petitioner does not wish to press of petition any further, accordingly the same stands dismissed. On withdrawal. You want to withdraw?
Mildly. Why did you approve the authority, appropriate authority?
Withdraw the writ petition and approach the appropriate authority. Interim orders, if any, stands located.
No interim order.
And pending ayes are also dismissed.
Obliged.
Mehdi Burman appears for
2, 3, and 4.
2, 3, and 4. MFG Hazarika for 1.
Obliged.
I think 15.
I have received some instruction from, sorry.
One of the joint verification reports my lord, of 26/9 and my lord, 3/11. And instruction from the ADC, my lord. It says, my lord, copy the just a minute.
Yes.
If I may please letter, my lord, 29/1/26. With reference to WPC number 6363 of 2025 in the matter of Rabiul Hussain and others, it is to inform you that the boundary demarcation carried out during the joint verification of by the Revenue and Forest Department has been found correct and duly established on ground verification. Accordingly, the area presently under occupation of the petitioners, DAG number 442, 88, 89, and DAG number 50, mentioned in their petition falls within the government notified boundary of Dohikota Reserve Forest, and they are encroaching the Dohikota RF land. It is further informed that as per the Bhunaksha records, the maps of Dasabhuja, Devasthan and Hatiapara revenue villages were prepared in the year 1960-61, whereas Dohikata was declared as reserve forest in the year 1973. Consequently, the boundaries of Dohikata reserve forest are not reflected in the said Bhunaksha maps. However, the joint verification copy enclosed conducted by the revenue and the forest officials has conclusively established that the land under occupation of the petitioners fall under the Dohikata reserve forest. Now, if we, my lord, turn to the next page, it is the first report pursuant to another order of your lordships. It is 26/9/2025 dated. This is joint verification, first joint verification report, my lord. It says, my lord, object, if we come to my lord, object of the joint survey, serial number 2, the joint survey was undertaken to demarcate the encroached areas within within Dohikata RF, identify specific blocks to be taken up for eviction, record ambiguous land parcels where patta and other rights are claimed, exclude areas currently under the consideration of rights settlement under the Forest Rights Act 2006, encroached blocks identified for eviction. Based on field verification and joint inspection, 7 encroachment blocks have been delineated for eviction. The list of coordinates for each eviction block is enclosed as Annexure B. The corresponding KML image as appended in as Annexure B2. It is clarified that blocks inhabited by tribal population where the FRA allotment process is ongoing have been excluded from the present eviction plan. Eviction, if any, in those blocks shall be taken up only after completion of the FRA exercise. During the joint survey, area with claim patta rights. During the joint survey, 2 blocks, Block 1 and Block 2, were found to contain land parcels where claims of patta rights have been recorded. These portions are kept outside the scope of the present eviction operation, pending a final decision by the competent authorities. The coordinate of these ambiguous land parcels are enclosed as Annexure C1. Date of survey. The joint survey was carried out on 23/7/25 in compliance with Honorable High Court's order. Officials, these are the officials present of Revenue and Forest Departments, my lord. Then if we turn to the next page, these are the coordinates of the forest boundary, which is very technical for us, my lord. Then, my lord.
No, insofar as the petitioner's parcel of land is concerned.
My lord.
So they say that it is covered under DAG number so, and they fall within the
Yes.
reserve forest.
Yes, my lord.
But this was not reflected in the map because the reserve forest was declared later.
Exactly, my lord.
Right?
So the map that we have produced now, my lord, it's based on the these same coordinates, my lord. It contains their names, my lord,
Now,
inside the forest.
these land reflecting the map reflecting the land parcel out
My lord.
inside the reserve forest.
My lord.
Has it been settled with them?
No, there is no settlement. That is what I'm all along I'm submitting, my lord. This is a forum, my lord. Article 226 is for enforcement of a right pre-existing. These people, my lord, have miserably failed to make out a right, my lord. Not to speak of, my lord, enforcement, but they are
So
basically
were
asking for a declaration.
They were simply in occupation.
They're simply in occupation. Just to, my lord, bypass our endeavor, my lord, they are claiming it's a revenue land. So fresh notice from the revenue authorities are to be required, my lord. But for this making these statements, my lord, they have nothing. There is no title, there is no patta. Sometimes they say it's a government land, sometimes they say pattas were issued. That's why, my lord, if my lord peruses the last verification report, my lord, in the same bunch, my lord, after the coordinates, one more important thing, my lord, after the coordinates, my lord, will see, these are the persons, my lord. Annexure C1 at the top, my lord, after the coordinates.
C1.
Yes, my lord, due to positive time, I could not designate it. Just now I have received. After the, my lord, map, there is one map, then C1, Annexure C1 at the top.
No, there is one annexure B,
Yes.
and after that there is annexure 1, 2, and 3. Annexure B is joint verification report.
Yes, my lord.
Then annexure 1 is the details of the patta rights.
Yes, that is where I am, my lord. These are the details of the patta rights. These persons have been excluded, my lord. Making the same claim, my lord, these 3 petitioners along with 56 others instituted a writ petition. If joint verification was directed, we did it. We found among those 59, 6 were having patta. Then again, we have excluded them.
The,
But-
these 6 persons' land is included here.
Here, my lord, we have excluded their name, my lord. And my lord will see the annexure B, my lord, dated 3/11/2025, my lord.
Yes.
This was done, my lord, in strict compliance of your lordship's earlier order, including the order passed in the writ petition instituted by the petitioners, my lord.
All right. Yes.
My lordship, from the letter dated 29/1/2026, my lordship, in the second paragraph, it is stated that it is further informed that as per
No, first tell us, do you have any land documents on this land?
we are not disputing that it is a government land, my lordship.
Oh.
We are landless people, so our
Have you made any application for settlement of this land?
my lordship, even in earlier, my lordship, notice has been issued from the revenue department for our eviction, my lordship. At that time, we have requested the revenue department allowed us to stay, my lordship. Kindly.
No, we are asking you whether have you made any application? For how long have you been this land are under your occupation? For how many years?
My lordship, I have annexed several documents, my lord. 1960, my father's name is also there.
1960. From 1960, you did not make any application for settlement. That these lands will be settled with you because you are on this land under occupation of this land.
My lord, there are even court cases, my lordship, regarding that, my lordship.
So go and pursue those court cases.
My lord, our dispute is with the forest department, my
No.
lordship. They are saying that.
In view of this, there is a joint verification. The revenue department has given a finding that it is within the forest area.
My lord,
So therefore, the forest department is within its rights to issue notification.
my lord, they are saying that this that is the map, my lordship, Dasha Bhuja Devasthan, my lordship, that is revenue and department. It was published on prepared on 1960-1961, third paragraph. Second paragraph, my lordship. It is further informed that as per Bhunaksha records, the map of Dasha Bhuja Devasthan and Bhatiapada revenue villages were prepared in the year 1961-61. So, my lord, if it is prepared under 1960-61 and later on it has been converted into reserve forest, my lordship, then provisions of section 6 to section 17 will apply, my lordship, of the
No, the
Forest Regulation Act
question,
1991, my
the
lordship.
question which we are asking you is for which you have given us no answer. Is that only land which was under your occupation since 1960?
We have.
You have not-
Under Vasundhara scheme, we have applied, my lord.
When? Where are these documents? Where are these documents?
That has been not.
produce, my lord,
Huh?
give a date, we will produce, my lord, that.
What are you doing? You are coming to the court asking for interim orders. You are not coming with clean hands. Why have these documents not been produced? Why should we give you that indulgence? You are the one who has come and saying that you have been in the land from 1960. That's the
Some earlier.
fundamental, it's a foundational fact that these are our documents. We are on this land for last so many years. Forest cannot evict us. That should be the foundation of your claim.
Some of the documents, my lordship, very.
In a writ court, we can't help you. You have other forums. If you want to go, you go there.
My lord, after the eviction notice has been issued, we deliberated and we are collecting the documents in our favor, my lord. Some of the documents in the additional video we have given, we discovered later, my lordship, because in urgency, my lordship, most of the documents were not with the petitioners, my lordship. And in Vasundhara also through online they have applied, my lordship.
Is there any interim order here?
There is no interim order, my lord. Since there was a request from the court, my lord, I instructed my client not to proceed, my lord. And if I may submit one thing, my lord, under the Assam Forest Regulations, my lord, once a proclamation, intention of declaring a forest is issued, no further right can be accrued. And once the final declaration is made, just prior to that, my lord, all claims are settled. We have to settle all
What was
claims.
done in 73?
1973. And secondly, my lord, if they want to take recourse to forest rights act, my lord, they have to be a scheduled tribe or a forest dwelling indigenous person. For that, my lord, the test is 3 generations, my lord. One generation constitute 25 years. So they have to show that they are forest dependent, plus they are there since 1930.
For that, my lord, at least we should get the notice, my lordship. Nothing we have
We have
got.
given the notice, my lord.
If they have acquired, they're saying that it has been acquired 1973 and that map is of 1960-61. Then
Basically, my lord, these
right to
petitioners
get
are
the-
trying to reduce this
get the
because
protection
constitution
under,
plus
forest
trial
rights
court,
act,
my
my
lord.
lordship.
He's
Because
trying
law
to
is there to protect us, my lordship.
To protect you, provided you have a right. You have to establish your right.
At least to get the notice, my lordship.
What notice?
Under that is
1973, my lord, that
section
notice
6
now
to
he
11, my lordship, Forest Right Act.
Huh?
For section 6 to section 17 of
No,
Forest Right.
Forest Right
For
Act.
not Forest Right Act, Assam
Forest Act.
Forest Regulation.
Forest
19,
Regulation,
1891.
which was entered in
You look
1973, my lord.
into, you look into the papers which may be available with your grandfather. It may be there.
No, my lord, their grandfathers were
1973.
from the north bank of Brahmaputra, my lord.
You are
Borpeta.
asking notice now.
And they could not produce the original map of the
Can be
forest,
done.
my lordship.
What can be done?
In the original notification, it is not. Can you see, my lordship? It is
Learned counsel for the parties. Petitioners before the court. Are aggrieved by the notification, notice. Where is the notice? Where is the notice?
Yes.
28, page 28, my lordship, of the writ petition.
Notice dated 6th of November 2025, issued by the District Forest Officer, Gwalpara Division, within bracket T, whereby the petitioners whereby the Forest Department, upon examination of the representations filed by the petitioners, have found that the petitioners are encroachers within the Dohikata Reserve Forest, and they are directed to vacate the land within 30 days. And in the event of their failure to vacate, eviction proceedings will be initiated by the Forest Department. Stop there. The petitioners claim to be residing in these plots of land since the year 1960-61. It is their claim that at the relevant point in time, it is their claim that these areas are outside the reserve forest area, and therefore the Forest Department does not have any power to issue notification for eviction. Stop. If any notice is to be issued, it must be by the revenue authorities, as these areas are outside the scheduled area of the reserve forest, Dohikata Reserve Forest area. The writ petitioners initially approached his court by filing WPC 6217 of 2025,
Assailing the same notice, my lord.
Selling the same notice, which came to be disposed of by an order dated 3/11/2025. With the following order, para 8, 9, 10, 11, 12. Para in deference to the directions issued by this court.
Another joint verification, 311. No.
A joint verification on by the Revenue and the Forest Department was undertaken on 3/11, and in terms of the said joint verification report.
Speaking order, sorry.
Where is that speaking order?
It's my, in my affidavit, my lord. Affidavit in opposition. Page 53, my lord.
The speaking order was issued on 6th of November 2025,
Rejecting their claim, my lord.
rejecting the claims of the writ petitions. Stop. Being aggrieved, the petitioners are before this court. Correct. The respondents, although notices were not issued in the matter, the respondents have contested the claims of the petitioner by filing their affidavit in opposition. Stop. The respondents rely on the joint verification report undertaken by the forest as well as by the revenue department to contest the claims of the writ petitioner and submit that the land which is stated to be under occupation of the petitioners is under the Dhoikota forest, reserve forest, and therefore as per the data available in the joint verification report, since this area is within the defined area of the Dhoikota Reserve Forest, the forest department is competent to take all necessary steps to secure this land if required by undertaking eviction proceedings. Stop. Since the land claimed to be under occupation of the writ petitioner is within the forest area, there is no necessity for the revenue authorities to undertake the eviction process. Stop. The matter was heard on several days, and the respondents were permitted to produce the joint verification report. This joint verification report dated 3/11/2025 has been placed before the court today. In terms of the map and the coordinates which are reflected in the joint verification report, the land stated to be under occupation of the writ petitioners is within the notified boundary of the Dhoikota Reserve Forest. And therefore the authorities have issued the notices for eviction of the writ petitioners. These DAG numbers that are reflected, DAG 422, 88, 89,
My lord.
these are DAG numbers under whose possession?
It's a forest land, my lord.
No, is it under the occupation of the petitioners?
They claim, my lord, 422, 88, 89, and 50. They claim, my lord, but this is a forest land. my lord.
One of the claims of the writ petitioners are that the land which is under their occupation is a government land covered by DAG number 422, 88, 89, and 50. Stop. The learned counsel for the petitioner submits that this land, being a government land, even assuming, though not admitting, that the petitioners are unauthorized occupants, then the power to issue eviction notices lie with the revenue department and not with the forest department. Stop. This contention of the petitioner, however, is belied by the joint verification report dated 3/11/2025, where and the findings of the forest officials, which reflect that in the cadastral maps pertaining to the year 1960-61, these lands were included in the revenue cadastral map. However, the Doikota Reserve Forest was declared in 1973, and these plots of land thereafter have been included within the notified boundary of the Doikota Reserve Forest. Under such circumstances, as on date, there can be no claim by any person to say that these are government land on which they are, which is under their occupation, and therefore it is the Revenue Department who is bestowed with the power to either settle the land in their favor or to undertake eviction process, and not by the Forest Department. Stop. Better. Having heard counsel for the parties and upon perusal of the pleadings available before the court, as also the orders passed by the court, that writ appeal 251 is also relevant here.
Because my lord, notice we have issued is in compliance with 251, my lord. If my lord peruses the notice, if you notice, it was in terms of that.
That 251 is here.
250 and not annex, well, I have a copy, man.
All right.
Para 21.
In this context, it is necessary to refer to the order dated so and so passed in writ appeal 251 of 2025, whereby in a similar matter, which went up to the which was assailed in the intra-court appeal, over the division bench of this court had laid down certain guidelines which are extracted below.
Para 21, man. The 21 and 22, man.
No extract over anymore. Fair enough. The Forest Department, the averments made in the pleadings of the Forest Department, as also on the submissions made by the learned additional AG on behalf of the Forest Department, is that in terms of the guidelines or directions issued in writ appeal 251 of 2025, the steps, the Forest Department has strictly adhered to these guidelines by issuing notices and giving opportunity to the petitioners to support their contention that the land under their occupation is within the revenue area, not in the forest area. Stop. However, no such, no satisfactory document could be furnished by the petitioners during the period. It would be furnished by the petitioners in spite of opportunities being granted. So that apart, the joint verification report dated so and so clearly reflects that the area claimed to be under occupation of the petitioners within the notified boundary of the Doikota Reserve Forest. Stop. This is also not disputed by the revenue authorities, as is reflected in the joint verification report. Under such circumstances, this court does not find any merit in the writ petition to interfere with the process of undertaken by the Forest Department. Writ petition being devoid of merit accordingly stands dismissed. No order is enforced.
Deeply obliged.
Highly obliged, my lordship.
Item 16.
Yes.
Instruction has been received, madam. Order 44. It can be disposed of in terms of your lordship's earlier order.
That is 27-1
Malo.
Yes, madam.
in WPC.
But
Physically, madam.
242 of 2020.
Physically, okay.
Malo.
Right.
Only, it says out of 449 families, you are issued to 449 families, my lord. Only 289 petitions have been received from only 289 persons.
Rest, they are not coming, my lord. Responding,
Whatever it may.
my lord,
So we'll close it in terms of this.
my lord.
Third counsel for the parties, dispose in terms of this order. Siddiq Ali.
My lord, I have a copy for reference.
Judgment,
Yes, that
it's
also.
here.
Come on. Okay.
Even over here. 16.
17 listed for the first time, my lord.
এই আমার আগৰ 215 আছিল নেকি?
Bhuven Boru, no?
Bhuven Boru.
Yes, 17.
This 17 is a case, my lord, is a slightly in a different footing, my lord. He is, my lord, belongs to that protected class person petitioner before my lord, my lord. And his land, my lord, has been given with a tenancy agreement to some of the private individuals to do as a, my lord, like the tenancy rights, my lord. Now, the original land, my lord, the record of the land has not yet been mutated nor transferred in the name of these, my lord, persons. So, my lord, now the government is now initiating the process to, the land is also a patta land. So therefore, my lord, they are now trying to take over the, my lord, land by virtue of this process that this has been occupied by a non-protected class persons, my lord. And we have annexed the Jamabandi for surveyed village also, my lord.
Where is that impugn notice?
My lord, the notice is, my lord, the same. My lord, may be pleased to find page number 46, my lord. That not addressed to me, my lord.
You are an occupant
My lord, occupant by virtue as a tenant, my lord.
as a tenant.
As a tenant, my lord. An agreement has also been executed, my lord.
Who is
Lord,
the original owner?
Habibur Rahman, my
This petitioner, my lord.
Then
This petitioner is the original owner. Notice had been issued to my tenant saying that as this tenant is, my lord, occupying the land unauthorizedly being a protected class land. So therefore, he has been asked to vacate.
what notice is issued to Habibur Rahman?
That's correct. He is the, my lord, tenant, my lord.
Huh?
He is the
He is
tenant,
the
my lord.
tenant.
My lord.
Okay, okay. The petitioner is the owner.
Owner, my lord. I have annexed the Jamabandi copy and other land records also, my lord.
Oh.
It has not yet been, my lord, because there is no sale. As per my lord, my lordship knows, my lord, chapter 10 says that until and unless the land is mutated in the name of non-protected class, there is no violation, my lord.
Where is the agreement?
My lord. My lord, now kindly turn to page 44, my lord. 45 is the original one, my lord. And 44 is the translated copy, my lord.
This is hardly an agreement.
My lord.
Yes. What kind of an agreement is this?
Lord, these village people, my lord, do this type of agreement. But my lord, admittedly, I have not given over the land the full, my lord, ownership has not yet been changed, my lord.
Land is mutated in your name.
It is in my name, yes, my lord. It is in, my lord may be pleased to find the mutation, the land record patta, my lord, is at page 41, my lord. 1, 1, 2, 1, 2. But it is still in the name of my father, my lord. The Narsingh Boru is my father, my lord can verify it from. And in the, in the next page, my lord, page 42 is Sri Bhuven Kuan.
The joint patta.
My lord, my lord.
And these others are your.
My relatives, my lord.
Prima facie, it appears that he is the owner.
I'll get the instructions. It's a so cause, my lord. You know, let can it be on Wednesday, my lord? We'll get the instructions.
Yes, yes.
My lord, tomorrow is the last date as per the notice, my lord. So it's status quo, my lord. Till document been done.
Lordship, may I please, as because item number 18 is also similar,
Hmm.
and I am in item number 18.
Right.
That's why Lordship, if your Lordships comes to the notice, that is at page 47, item number 17. It's not an eviction notice, it's a show cause notice.
Hmm.
So let him place all these documents before the, is it not premature, Lordship, at this stage? That's because he has only been asked to place all the documents before the circle officer. And Lordship, the notice is dated 23/12/2025, and he was given 15 days time. This third paragraph, হে ধাৰা সোয়েনছো মতে অহা 15 দিনৰ ভিতৰত জনজাতীয় খণ্ডত ভূমি অধিকাৰ সাব্যস্ত কৰাৰ বাবে প্ৰয়োজনীয় নথিপত্ৰ প্ৰমাণ দাখিল কৰাৰ বাবে জাননী প্ৰেৰণ কৰা হ'ল। জনজাতীয় খণ্ডত ভূমি অধিকাৰৰ যোগ্যতাৰ প্ৰামাণিক তথ্য ৰাজহ চক্ৰ কাৰ্যালয়ত দাখিল কৰিব পাৰিব। অন্যথাই এই জাননী গ্ৰহণ কৰাৰ 1 মাহৰ ভিতৰত উক্ত ভূমিত থকা ঘৰ, দোকান, শস্য বেৰা আদি উঠাই নিবলৈ কোৱা হ'ব। So
That's
he has,
line.
yes, Lordship, no. Initially, Lordship, it's a so-called notice.
No, that's right.
If he fails, like the 337(1)(2) notice of the Guwahati Municipal Corporation. 337(1)(2) notice, it's a so-called notice. If he fails, then 337(3) notice is issued. Like this, Lordship. If he fails, and the person concerned who has been given the notice, he is not before your Lordship, is there? The owner has before your Lordship, and the Lordship kindly see the agreement, Lordship. There is no cut-off date, nothing, Lordship.
Yeah,
It is not
that's
even
what we-
registered.
The lease agreement always should be registered, my lord. And in a tribal,
My lord.
So you file.
Yes,
File
Lordship,
your
let it
response.
place.
No, my lord, with all respect of my respected senior friend submission, my lord, my case is that, my lord, this notice has been issued to my tenant.
Hmm.
It ought to have issued to me, my lord.
No,
If the notice is issued to me, then I can go and have the
no,
opportunity.
no.
Because, my lord,
You will not be issued a notice because there is no need for
Yes,
the
Lordship.
authorities to issue a notice. They have, let us assume, they have some information that this land has been purchased or taken on very long lease by a person who does not belong to the protected
my lord,
community.
probability may be there. I'm not denying that.
Therefore, they are issuing a notice.
Yes.
No,
So-
this notice is issued to my tenant, my lord.
That's right.
Now, my lord, if I am a landlord, my lord, if I have a tenanted house in my residence, my lord, if the GMC or some other authority obviously will issue notice to the landlord, my lord.
No, you're right.
My
But here is a case where the notice is issued with the presumption that the person in occupation is not authorized.
Yes, Lordship.
So the person in occupation has to give his documents before the authority to
Mal.
say
Mal.
that I'm authorized.
Yes,
Okay, this is the
that
agreement
must.
or
This
whatever it
notice
is.
is that notice only.
Mal.
That you do it.
Yes, my lord. In that line, my lord, my lord can dispose of this petition also. In the similar line, my lord, that will place it before the authority. my lord.
As
They
because
will-
the time has already gone, Lordship may give them only a limited time, Lordship. As because it was of 23 December, 23rd of December. Today is 20,
Ninth.
Line.
yes, Lordship.
Heard learned counsel for the parties. This petition is filed by
15%, no? That's
the owner of a plot of land. Assailing the notice dated where is the notice again?
My lord, page 46, my lord.
46 is the translated one, vernacular one, 47.
47.
Notice dated 23/12/2025, whereby the tenant of the petitioner who was put to notice was directed to submit required documents and proof asserting land rights on the land within the next 15 days, as per section 165 within bracket 1, then bracket 2, bracket 3, then bracket small a and small b. The Stop. The learned counsel for the petition.
It should be ko and kho, lordship. In the vernacular, it's written as ko and kho.
And
Co and co. Three co, co. The petitioner submits that the action of the revenue authorities in issuing the impugned notice to his tenant is contrary to the provision of law, inasmuch as the petitioner belongs to the protected community of a borough, is a borough kachari
Boro Kachari, my lord. It is the class.
belonging to the borough kachari community, and he owns the said plot of land.
Well,
And by virtue of a lease agreement, the tenant, namely so and so, has been permitted to stay on the said land. Look, learned counsel has referred to the house rent agreement, a copy of which is enclosed to the writ petition also. The counsel for the petitioner submits that the revenue authorities could not have issued the notice to the tenant. Rather, the same ought to have been issued to the petitioner. And as a consequence, the petitioner is not in a position to submit irrelevant documents. Therefore, the present writ petition has been filed. Mr. N. Das, learned counsel, appearing for, you are in this matter?
Lordship can,
Mr. N. Das, counsel for the petitioner,
my learned friend's name may be recorded.
submits that this notice is only a notice to, notice inviting the noticee to submit all relevant documents in support of the claims. This was 15 days time was granted. However, the noticee has not taken any steps to submit the relevant notices or supporting documents. Therefore, at this stage, the writ petition is premature, as no steps have been taken by the authority to evict without verification of the documents, which, however, will have to be submitted by the writ petitioner in the first place. Stop. Where having heard counsel for parties.
And we are also disputing the agreement, lordship. If your lordship go by the agreement,
the learned government council also questions the authenticity of the land house rent agreement
it is not
executed
even
by and
registered,
between the
not
petitioner.
even registered.
Stop. On the ground that the same has never been registered. But having heard counsel for parties and upon perusal of the pleadings available in the writ petition, it is seen that the respondent revenue department has issued a notice to one Habibur Rahman, son of Abdul Latif. Stop. The petitioner in the present case is Bhaven Boro, alias Kuan, who claims to be the owner of the said plot of land. Stop. The petitioner claims to have executed a house rent agreement with the said Sri Habibur Rahman, by virtue of which the tenant was permitted to occupy the said plot of land. Stop. The contention of the writ petitioner that the petitioner cannot submit the relevant documents as the notice has been issued in the name of the tenant cannot be accepted, inasmuch as even assuming the notice is issued to the tenant, even assuming that the tenant is the noticee, then the tenant is also within its rights to produce all relevant documents, including any such agreement executed by and between the tenant and the petitioner before the authorities. Stop. If the authorities are satisfied that the tenant is merely an occupant on the land with due permission from the original owner, namely the writ petitioner, who is a member of the protected community, then the occupancy of the tenant on the land within the areas
By
reserved for the protected community can be accepted, and the tenant can be permitted, and the petitioner and the tenant can be permitted to continue with their agreements. Stop. The owner, having executed the agreement, is also within his rights to go and produce all relevant documents before the authorities, notwithstanding the notice being issued to the tenant. Stop. Under such circumstances, at this stage, this court is of the view that the petitioner and obligor his tenant, Habibur Rahman, be permitted to appear before the Circle Officer Morigao and furnish all necessary documents within 15 days from today.
Lordship, let it be 5 days, Lordship, as because that time has already elapsed. Otherwise, I would not have,
Please.
Lordship.
10 days, my lord.
As because these are the
Right,
documents.
7 days from today,
My lord.
which will be 5th of February. Stop. If the petitioner or the tenant files the necessary documents in pursuance to the notice dated so and so, then the revenue authorities will examine the matter and pass appropriate orders. Stop. If on the other end, the petitioner or the tenant fails to file any document in spite of the liberty granted by this court, then the revenue authorities are within their rights to proceed in the matter as per law in terms of the notice dated 23/12/2025.
My lord,
It is made clear that this court, while disposing of the writ petition, has not expressed any opinion on the merits of the case.
Lord, but till the decision is taken, my lord, then they will not resort to.
That is already
It is
there.
needless to say that till a decision is taken by the revenue authorities, the revenue authorities will not proceed to evict
My lord.
the petitioner or the tenant.
My lord.
This court.
Obliged. The second item is also similar.
18, I am just placing one thing, Lordship, before your Lordship. Your Lordship may kindly come to page 47. Otherwise similar, but I will show that regarding that agreement. Page 47.
Yes.
In the witnesses, in the earlier case, there was only one witness, this is Dasarat Das. This Dasarat Das is also here. And this Habibur Rahman, the tenant of the other case, Lord. So
They
now
are
I
you
think,
neighbors?
Lordship, this type of cases will come now.
Are you neighbors?
Yes, yes, my lord.
There's no technically, there's no bar for.
Yeah, there is no bar, but something is there, Lordship. But even then, Lordship, I am not.
That's something you have to trace
Get
it out
Lord-
on the documents which are furnished before the authorities, if required, disposed of.
My lord.
The
Yeah.
second one is also same, Lord.
Same order, disposed of, Mr. H. Sharma for the respondents.
2.2. It has.
Yes.
My lord, this is also the same area, same petitioners, my lord. Some were left out, which my lordship has disposed of just now, my lord. Item number
In that
16.
Sulaiman,
Item number 16, my lord, Abbas.
Sulaiman Ali or something.
No, Siddiq Ali, my lord.
Siddiq Ali.
My lord.
Same order.
Same order, my lord, can be disposed of. my lord.
Yes, respondents.
Asset. Same line, it can be disposed.
But again, the question would be that they have no instructions.
Yes, my lord. For this person, the instruction is awaited, my lord, because this is the first time it has come. But my lord, my instruction is that, my lord, to the responding to the
Instruction,
notices, this person has already submitted, my lord, and process is going on, my lord.
Then we dispose it off,
My lord.
asking the revenue authorities to take necessary decision on the basis of the notices.
Siddiq Ali, it can cover, my lord, same area, my lord.
Have you been served with a copy?
Yes,
No, copy has been served, but the early in item number 16, your Lordship has directed them to obtain instructions, directed us to obtain instructions.
Earlier, yes.
But this is the, for
No,
the
here-
first time.
Here we need not restrain ourselves in that. We can say, recording the statement of the petitioner, that he has already submitted documents. If that be so, then the authorities will consider and
Lordship,
dispose
lordship,
it.
lordship, that
Right?
can be done. Yes,
Right.
lordship.
Dispose it to Agor Siddiq Ali. Only
Right.
thing is that a government was permitted to obtain instructions. How to do on Alaga. Yet the petitioner council has submitted that he has already submitted the necessary documents before the authorities in pursuance to the notice. Therefore, the authorities will now decide the matter and pass appropriate orders. Baki kini hai kita. Dispose. It's Sormut.
Abbas and Pons, no?
20.
Because poison okay, I say. 20. My lord, this is also similar with that Siddiq Ali and my lord, this item 20, my lord. Abbas Ali.
You have submitted.
Yes, yes, my lord.
You
In
sub-
para 7, my lord, they have mentioned most of the petitioners, may not be the all, my lord.
Whoever it is there.
Fine.
Whoever it is there. Eight will go to a they submitted. Huh? MS Borman, M. Borman. Government advocates.
Related to my own revenue, sir.
21.
What is the particular one?
Yes.
My lord, this is a, my lord, claiming to be a forest area by the authority, my lord. But in fact, my lord, we are residing in a, my lord, revenue land. That is the issue, my lord. And some judgments and order had been passed by this honorable court, my lord, directing them to demarcate, my lord. The forest authority in collaboration with the revenue authority, my lord. So this notice had been issued on 8/12/2025. So
It's prescribed by joint verification.
joint verification.
This can be disposed of since they are raising claims that their areas are within revenue areas. Lordship can direct us to pass a joint verification in their presence. It can be disposed of in that line.
In which forest area?
Lutumari, my lord.
Lutumari.
There you have not undertaken joint verification.
We have undertaken. Since they're disputing once more if they want in their presence. Otherwise, we have taken.
Is there a notice issued?
Yes,
Notice
my
has
lord,
been
page
issued, my lord.
97, my lord.
Notice in compliance of the order of the division bench.
252.
251 and 252.
251 and 252.
Where is the notice?
Lord, it will start from page, my lord.
Lot of here it's 81.
Page number 88, my lord.
80%.
Starts from page 18. my lord.
But if you have already taken a joint verification, why should we direct another
I mean,
joint
in-
verification?
In our area, my lord, we have not found any authority coming and doing
Oh.
the joint verification, my lord, in our house or property, my lord, therein.
In that case, Lordship, I can bring in instructions, my lord. That this area has been covered by joint verification, my lord.
You
If
get
already
it
done.
by 2 o'clock? No.
2 o'clock will be difficult.
Right.
Come on.
I heard planning council for parties. The petitioners are agreed by the impugned notice dated 8/12/2025, issued by the forest department on the ground that the land under their occupation falls within the Lutumai Reserve Forest area. So there are Mr. D. Gugoi, learned counsel appearing for the forest, submits that joint verification has already been undertaken by adhering to the guidelines issued by this court in Writ Appeal 251, 252.
251 and 252, my lord.
251 and 252 of 2025. Nevertheless, the council submits that you would like to obtain the instructions on the matter. List again.
Monday,
On-
man. I can
on-
bring it this Monday, man. Next
Monday, second,
Second.
on second. Till the next day, status quo be maintained.
Okay.
Although notices are not issued, extra copies be furnished.
Yes, yes. my lord. Okay, no?
Soft copy to be seen.
Highly obliged.
Daily list order, that is one.
My lord, here in this case, my lord, we have taken steps upon all the respondents, my lord. And as per Honorable Court Order dated 10 March to 25, my lord, paper publication is done and affidavit also filed. The only issue is that, my lord will find one orange color flag mark in the record, my lord. That Kamrup Amingao, my lord, the Deputy Commissioner Kamrup, my lord, submitted one status report, my lord. Similarly, my lord, Kamrup Metro was supposed to file that same status report, my lord, but till date, my lord, no such report is filed, my lord. And White order dated, my lord, 25/11/21. And my lord, last order 10 March 2025, 10/5. It was reflected, my lord, that respondent number 3 is to place instruction as directed by this court on 25/11/21. My lord,
Status report relating to what?
Who are 6 and 7?
6 and 7 are, my lord, that husband and wife, the owner of that matter, DSP Leasing Limited, my lord.
Where is your affidavit?
Affidavit is filed, my lord, record, my lord.
Where was this published?
My lord, 2 daily newspaper, my lord. One is my lord, in the affidavit, my lord, page number 69 and 70, my lord.
Paper দুখন লেখা নাই। Paper দুখন লেখা নাই। Paper ৰ নাম চাম নাই।
One is Ogrodut, my lord, and other one is
Was not mention the names also.
You don't mention in
Yes,
which,
my lord.
it's,
which paper.
one is Doinik Ogrodut, my lord, some is paper, and other
You
one
have to
is
mention it. Come to para 376.
This mention should be made. no?
You have said it is one daily English newspaper, one daily Assamese
Yes.
newspaper.
yes,
Which newspaper? In which edition?
madam. Apology, my lord, I forgot to mention the name, my lord.
Not only name, you have to give the edition. On which date was it published?
Authentication to like.
Yes,
And you enclose the proper copy. What is this? You are enclosing only the extract.
one is Sentinel, and other one is my lord Ogrodut.
Bring it on record.
My lord,
We want your statement here.
my lord.
You have filed an affidavit.
Otherwise, my lord, I annexed that those 2 paper cuttings, my lord, but
You
forgot
show
to
us from the
mention.
paper
Yes,
cutting, where is the name of the newspaper and on which date?
my lord.
Date of publication. Even in para 3,
It is not mentioned.
you have not mentioned on which date it has been published. This is the crucial information.
Right, my lord.
And you should enclose the newspaper here. Right.
But we'll
Counsel
file
for
one
publication.
another I am, madam.
The petitioner counsel
Additional affidavit, madam.
in reference to the order dated 10/3/2025 submits that paper publication has been done and an affidavit of compliance has been filed to the effect. So, however, in the affidavit, in the additional affidavit which has been filed on 17 December 2025, although at para 3, it is mentioned that in deference to the order dated 10/3/2025 paper publication upon respondent 6 and 7 has been done. However, there is no reference to the name of the newspaper and the edition on which date the publications were made. Secondly, the enclosures to the affidavit contain only photocopy of the specific advertisement, specific content regarding the publication of the notices. So, under such circumstances, we permit the counsel for the petitioner to bring on record the necessary information in support of its claim that it has published the notices in terms of the order issued by the court.
My lord,
2 weeks time, matter be listed after 2 weeks.
my lord, regarding that, my lord, Kamrup Metro, my lord, status report.
You first
I'll
get
go
over this.
in the meantime, the necessary action I will take on my part without direction also. If you have.
Okay.
I think the
Yes.
Before my learned friend starts, my lord, the application filed under Article 226(3), in my humble submission, it has become infructuous. If your lordship wants to hear how it has become infructuous, otherwise, my lord, my learned friend may argue on that, because it is as per the full bench decision of this honorable court, my lord. It is now lost the force, my lord.
There was some interim order passed.
My lord.
When was it passed?
It was passed on 3/9/2024.
With petitioner filed.
May I explain your lordship
Yeah.
chronologically?
First order is
3/9/2024. Thereafter, they
wait.
might
3/9/24.
24.
What was the order passed?
Order passed, my lord?
What
The
was that interim order passed?
interim order considering the nature of allegation, more particularly the allegation of collision between the police and respondent number 6 and 7. It is provided that the possession of the petitioner should be protected till the returnable date, and the local police, more particularly OC so and so, shall ensure the possession of the petitioners are not to be disturbed. So, my lord, accordingly, matter was sub judice before this honorable court. They entered appearance before this honorable court, my lord. In the main petition, they filed their affidavit, my lord. Affidavit in opposition.
When was it? No. When was this IA filed?
IA filed on 2/12/2025, after 1 year, your lord, more than 1 year.
2/12.
2/12/2025. And first, the matter was taken up on 19/12/2025. On that day, my lord, with the joint request, my lord, it was deferred. Accordingly, the matter was again fixed, my lord. 7/1/2026. On that day also.
1912 is the first day.
First day.
After filing on the IA. Is it correct? All right. Then 7/1.
Then 7/1, my lord, with the joint prayer. Why I am saying, my lord, there is a decision. Thereafter, my lord, 9/1.
Yes.
So, my lord, so far as, my lord, Article 226(3) is concerned, your lordship, there are two things, my lord. One is, my lord, ad interim order. Another is, my lord, interim order. Ad interim order is, my lord, when the order has been passed in absence of the person against whom the order has been passed. Or, my lord, the person was not present at that time. He is the affected one. When, my lord, that order, subsequently that person appeared, and it may be ad interim order may be modified or vacated or, my lord, extended. In that case, my lord, it converted into, my lord, interim order. And against interim order, my lord, Article 226(3) is not applicable, my lord.
What is the basis of your submission?
My lord, I am coming to the full bench decision of this honorable court, my lord. 3 judges bench, my lord, has delivered this judgment. First, your lordship may kindly see para 2.
Para 2.
Para 2, my lord. May I read, your lordship?
Yes.
The division bench of this court, by judgment and order dated so and so, in writ appeal so and so, deemed it appropriate that the issue as to whether sub-article 3 of Article 226 of the Constitution is directory or mandatory be referred to a larger bench. Taking into account the said learned division bench had opined that Article 226(3) of the Constitution of India is directory in nature, whereas the coordinate benches of similar strength of our High Court in the cases of so and so, so and so, so and so, so and so had decided that Article 226(3) of the Constitution of India is mandatory in nature. Now, your lordship may skip over. Kindly come to my lord, para 43, page 220.
Para?
43, my lord, 43. Third one from last page, your lordship.
Hmm.
As already observed hereinafter, an order passed which relates to Article 226(3) of the Constitution is an ad interim order. And it becomes an interim order when the High Court passes an order in presence of the parties to the lease or extends the ad interim order in presence of the parties to the lease. Under such circumstances, if the High Court, upon an application filed for vacating an ad interim order under Article 226(3), disposes of the said application by rejecting the application or by vacating, modifying or altering the ad interim order, or even extending the ad interim order within the period of 2 weeks from the date of the period of 2 weeks is to be returned, the ad interim order which was passed cannot be said that it would automatically stand vacated. The interpretation, in our opinion, would be in consonance with the reading of Article 226(1) and 226(3) of the Constitution. In as much as the power under Article 226(1) of the Constitution conferred to the High Court is a basic structure of the Constitution, and there being no bar under Article so and so to extend the ad interim order during the pendency of the applications filed invoking Article 226(3) of the Constitution. My lord may skip over and kindly come to the operative part, my lord. Para 45. Accordingly, we decide the reference as under. Article 226 of the Constitution is not a directory provision. It is mandatory, my lord. An order referred to under in Article so and so Constitution is an ad interim order. The said ad interim order is required to be of a limited duration, or in other words, the existence of the ad interim order has to be limited to the date so fixed. The ad interim order is converted into an interim order only after an opportunity of being heard is granted on the prayer for interim relief to all the parties to the proceedings. Thereafter, my lord, the High Court, on an application filed under Article so and so of the Constitution, may reject the application or vacate, modify and or alter the ad interim order, may extend the ad interim order in the presence of the parties to the lease. Once the ad interim order is extended, after hearing both the parties, it shall then be converted into an interim order, and the prescription for automatic vacation of ad interim order for not being disposed within 2 weeks cannot be applied. So in the present case, your lordship, interim order was passed on 3rd of September 2024. Thereafter, my learned friend appeared, filed affidavit, and it was extended in presence of both the party. Under such circumstances, my lord, now that ad interim order is converted into interim order, and Article 226(3) is not applicable in that case, as per the full bench decision of this honorable court.
So you are saying that extension of the order,
my lord,
in the presence of the council,
my lord,
is an extension of the ad interim order,
my lord,
even though it is not specifically mentioned.
my lord, this is my submission.
On what basis?
My lord,
On what basis are you submitting that the extension, you are the beneficiary of an ad interim order? Now, when the 226 petition is filed, on a given date, the matter is deferred to another date,
my lord,
as per the agreement of the
both the
parties to the
parties.
council. But there is no specific extension of the ad interim order.
It is there, my lord.
Where?
My lord, kindly come to first page, order dated 4/10/2024, 4/10/2024,
In the writ petition.
12/11 also, my lord, 12/11, my lord, 12/11.
12/11 of
2024, my lord.
12/11/24.
My lord.
No, this is prior to filing of the.
But respondent number 6 and 7 were present. What I am submitting before your lordship.
Hmm.
If the ad interim order is extended in presence of 6 and 7,
Hmm.
time was sought for by 6 and 7. In that case, ad interim order will be converted into interim order. And if it is converted into interim order, my lord, Article 226(3) will not be applicable. As per the prescription of my lord.
No. This is prior to filing the 226.
My
Prior.
prior to filing.
This was in your presence.
Lordship, the interim order was, I have filed the application for vacating stay on 2/12/2025. Thereafter, interim order has not been extended.
No, that is not the question put by the court. Interim order was given on 3/9.
3/9,
Then it was extended on 4/10.
14.
Were you present in the court?
No.
On behalf of the parties?
No.
And 12/11?
No.
My lord, name is there, my lord. They sought for time, my lord.
12/11/2025,
24.
24, A. Goel, learned counsel for the petitioner, is present. Respondent are yet to be filed counter affidavit.
Yes.
List this case 3 weeks. Interim order pass early shall continue.
And in the advocates column, my lord, Dr. R. Sharma, respondent number 6 and 7. Left hand side, my lord.
Good.
R. Sharma for respondent number
22/12/2024.
12/11/2024. My learned friend, earlier my learned friend was not counsel, my lord. Someone else was counsel. He appeared, my lord. And time was sought for by him. And it is reflected in the here, my lord. Name of the counsel is there. It is in order, my lord.
Which one?
On 12/11/2024, there is no continuation of the interim order.
Hmm?
On 12/11/2024, there is no continuation. 25.
But does it mean that an interim order specifically granted, if not extended, will amount to vacating?
On that is
Lordship,
also
we
a
have-
decision.
Last occasion, Lordship has heard the matter when Dr. Saraf was appeared as a counsel for the petitioner. And Lordship has 226(3)(b) was considered. 226(3)(b).
Hmm.
3B is regarding automatic vacation of the interim order after 14 days from the date of the filing of the application. This is not a case of 226(3)(b) now. This is a case where we have filed an application for vacating the interim order under 226(3).
Hmm.
We are not praying under 226(3)(b, considering the last order passed by the Honorable Court. But the option was opened by this Lordship. In the last order, Lordship has kept the option open. Considering the fact that after filing the application under 226(3)(b)(3), the interim order has not been continued within 14 days. That is on 12/11/2025. Interim order not continued. In the writ petition, Lordship will find.
Hmm.
Interim order was not considered on 12/11/2025. R. Sharma, learned counsel for the respondent 6 is present. List this case after 3 weeks. And respondent number 6/7,
When did you file your application?
we have filed the application for vacating on
2nd December.
2nd December.
But if you say that the interim order is not there on 12/11, why we filed the vacating petition?
Lordship, 226(3)(b). I am not praying under 226(3)(b).
Hmm.
226(3)(b) will come after filing the application.
No, filing the application for what? Assuming it is not under 226(3)(b. You are filing the application for vacating modification of an interim order.
Interim order.
That was filed on 17 December. According to you, on 12/11, there was no extension of interim order.
There is no extension of interim.
So why have you filed the interim, the application for vacating an interim order which is not there?
Lordship, if that is the Lordship, considering the facts of the case, that order has been accepted by the trial court, that there is an order from this honorable court, and considering that order, the lower court has passed injunction order.
That is on a then you challenge that injunction order. You are filing an application for vacating the interim order, and you are saying that the interim order has not been extended.
Interim order has not been extended, but subsequently it has been extended on last occasion, 7th.
That is a different issue. Last occasion, we have already, this order is before us. We have also given you liberty to that we'll consider it when it will not prejudice your rights. But your contention is that it was extended on a day-to-day basis, and then 7/11 or that 12/11/25, it was not extended. But you filed the application for vacating on 7 December. If it was not extended, if there is no interim order, why have you filed the application for vacating? And if you have filed an application for vacating, it means that it is in your understanding that the interim order is there.
Not my understanding only, Lordship.
Ah.
And that has been accepted by trial court itself.
Then you challenge the trial court order.
No, sir, I have,
What is the
I'm
vacating
go-
or not vacating of the interim
I
order
am-
got to do with it?
I am going to challenge the injunction order passed by the trial court.
Ah.
And my suit has been dismissed under order 7 Rule 11. Considering the interim order passed by this honorable court on the ground of limitation, it has affected me. That is why I have to file this application for vacating the interim order, because court has interpreted that this interim order is valid. If Lordship observed that interim order has not extended, so there is no question of filing the application under Article 23, then my case will be ended. If Lordship
There
observed
are
that,
judgments of the apex court where it says that when an interim order is extended, merely because in a subsequent date it was not extended, by operation of a dimming fiction that it gets vacated, is not correct. There
Yes,
is an
ma'am.
apex court
there has been
judgment.
apex court has said it is
Allahabad High
continued.
Court also.
Apex court says without vacating the interim order, it will continue.
Then,
Interim order is there.
so therefore, when you
That
say,
is why I have to file this application.
so why are you making the submission that interim order was not extended, therefore it's not there?
Today I am not making the submission. They are making the submission, Lordship. Today I am not arguing all these things. I have filed this application for vacating the interim order on
Alright.
different grounds.
All right. What are your grounds then?
Lordship, basically, this writ petition has been filed,
Hmm.
alleging that the affair filed by them before the police station was not considered by the police, by the Lisubari police station. And that is why they approached this honorable court for direction that police officers should register the case and make an investigation and obtain an interim order before this honorable court. And before that, there is title suit pending between the parties. Lordship will kindly see one thing. When they have filed an application under 226 before this honorable court, alleging inaction of the police, that police has not registered a case on the basis of their affair, there is a procedure laid down by the honorable CRPC as well as by the honorable Supreme Court and this court, held that when police has not registered a case, remedy is to file an application to the Superintendent of Police by registered post with AD.
That we have done.
And thereafter, Lordship, they have to, if that is also not considered, they have to file complaint petition under section 202 before the competent court of law, that is CGM. of
That
the
also
concerned
we have
police
done.
station. In this particular case, they have enclosed one document that they, Lordship will kindly see their writ petition, how they have narrated their text. Wants to this. Lordship kindly see, FIR page 112,
Of the writ petition.
writ petition.
Hundred and
112. Allegation is that I am an 84 years old person. They said they have a residential house situated in their own Medi land, out of which constructed their grandfather Rameshwar Bora in the year 1937, and also stole iron rods from the windows. In this regard, we further like to intimate that we inherited our said residential premises from our father Dipleshwar Bora, who inherited the same from our grandfather. His father, who possessed the said land property since 1933, since 92 years, Our family continues to possess, said residential premises. As we are residing at Guwahati at present, for our livelihood, our said residential premises is under lock and key. And by taking advantage of their absence, they unlawfully trespass into our residential premises and destruct our property. In this regard, I further like to intimate you that in the year 2012 also, Kailash Borthakur did the similar activities by claiming ownership of a portion of land of the said residential premises, and upon an affair lodged by my uncle, Sri Anup Bora, son of late Rameshwar Bora, is proceeding under section 145 CRPC of Crown. The height order dated passed by the learned executive magistrate Jorhat in miscase number possession of the said land was handed over to the suit us until decision by a competent court adjudicating him the entitled for doing so. Under such I therefore sincerely request you kindly to investigate the matter and book the culprits under appropriate provision of Bharatiya Nyayak Sanhita 2023 and to take appropriate measure as follows. Their allegation is on this basis of affair, police has not taken the action. Lordship will find in the page 1 and 2 itself. They have given this affair to the Superintendent of Police also. Page 112 again, Lordship. In the last portion, there is seal of Superintendent of Police received. Lordship got it on 17 August 2024.
Yes.
Now, may I take your Lordship to the affidavit filed by them? That is 17 August 2024. This writ petition affidavit has been shown page 78 on 20 August 2024. Lordship got it? Page 78. Lordship will find page 23. Page 23. It is 2nd September 2024. Page 23. On 2nd September 2024, they have approached this honorable court, filing this present petition that police has not taken any action on the basis of their affair. If that is so, Lordship, this court, as well as Honorable Supreme Court, held that if police has not taken an action on the basis of affair filed by them, it must disclose a cognizable offense. And if cognizable offense is police has not taken any registered a case, what is the remedy? Remedy is, Lordship, earlier case 156(4) of the Criminal Procedure Code. I will place the judgment also. 154. They have to make a complaint to the Superintendent of Police by registered post. If that also police has not taken any action, they have to file a complaint under section 202 before the CJN. In this particular case, without availing the remedy, they has approached this honorable court and obtained an interim order. There is a civil suit pending filed by us at the relevant time for Lordship not to disturb my position.
Your Lordship may kindly see page 116.
I am not disturbing when you are arguing.
Sir.
So in this particular case, what has been stated by them, Lordship will kindly see. Page 16. From para 23, Lordship will find. On 30th 2024 and 31 2024, private respondent again came back with large force armed with weapon and chased away the security personnel put up by the petitioner and threatened then those who would come in this way. Life of the caretaker, land and uncle of the petitioner 1, 2, 3, 4 under immediate threat. Petitioner cannot go back to their ancestral home because of their threat. Their ingress and egress to their patta land has been attached with the land in question has been blocked. As such, immediate interference of the Honorable Court has become essential to protect the life and caretaker and the property. Thereafter, private respondents are now trying to make construction over the land in question to change the nature and character of the land. Private respondents realize that the suit land have been filed hopelessly barred by limitation. As such, the suit will not succeed. As such, they are desperately trying to character of the schedule. They have already inflicted substantial damage to the property of the petitioner. The petitioner has approached the learned Chief Judicial Magistrate Court filing petition as the police did not register a case, but learned JMC Jorhat by order dated has simply posted the matter on 12/9/2004, basically leaving the petitioner remediless. Petitioner craved this honorable court to produce the order dated Iman and when required as later on. So in this particular case, they have stated that CGM has not taken any action on the basis of their complaint. When CGM has not taken any action, their remedy is under 482.
Yes.
So in this particular case, civil suit is pending between the parties without exhausting the civil suit. During pendency of the civil suit, they have obtained this interim order and direction was given to protect their property by police. Their right has been claimed on the basis of adverse possession. I'm a patta holder of the land. They are claiming on the basis of adverse possession. So in this particular case, because of this interim order passed by this honorable court, the trial court has passed injunction order. Considering the interim order passed by this honorable court, that has been influenced.
Where is that injunction order?
Injunction order, Lordship will find. I have annexed in my IA. Page 18, Lordship. Page 22 is the relevant portion.
Page?
Page 18 is the order of injunction dated 18/9/2025. And relevant portion, page 22. Page 22, Lordship. Petitioner also adduced the order of the Honorable High Court dated 3/9/2024. Lordship got it.
18. You're reading from 18.
Page 18, para, page 22. Relevant portion. Page 22.
Yes.
Third paragraph.
Okay. Hmm.
Petitioner have also adduced order that the Honorable High Court dated Iman passed in the Learned Counsel for petitioner has submitted the order of the Honorable High Court is still in force. In the said order, Honorable High Court has directed to protect the position. The petitioner also directed not to disturb the position. Petitioner of the said case are the same as the petitioner of the case in hand. On the other hand, Learned Counsel for the office submitted the said order is not final and reverse order may also come in future days. Hence, Learned Counsel OP has suggested to pass an order of status quo instead of granting injunction. So on the basis of this order, Lordship will find finally page 25. Page 25, second paragraph. Apart from that, already there is a prevailing order of the Honorable Guwahati High Court, whereby Honorable High Court has directed to protect the position of the petitioner, also direct not to disturb the position of the petitioner. If the right of the position of the petitioner are not protected, then it will contravenes the order of the Honorable Guwahati High Court also. Petitioner cited decision of the Honorable High Court. So considering the High Court's order, the injunction order has been passed. And already my submission will be also already there is an interim order. If interim order, injunction order, if injunction order is violated, there is a remedy for filing violation of petition for before the competent civil court.
Yes.
So my submission to be Lordship,
Mm.
when competent civil court is taking the matter and dispute is regarding property dispute, writ petition under Article 26 regarding property dispute is not to be entertained as per judgment of the Supreme Court. And regarding Lordship 226
What is the,
I
what
did-
is, what is the issue in the writ petition?
issue is a writ petition not taking action by the police.
Really?
Lordship, the Supreme Court has categorically stated in this regard, I will place a judgment of the Supreme Court.
Mm.
From 96 onwards, it has been followed. Two thousand eight to SCC 409, para 25.
Era?
25.
Yes,
We have elaborated the above matter because, Lordship got it?
yes.
We often find that when someone has a grievance, that FIR has not been registered at police station or a proper investigation is not being done by police, he rushes to High Court to file a writ petition or a petition under Section 482 CRPC. We are of the opinion that the High Court should not encourage this practice and should ordinarily refuse to interfere in such matter and relegate the petition to alternative remedy, firstly 154(3) and Section 36 of CRPC to the concerned officer if he is of no avail by appropriating the learned magistrate under Section 156(3). If a person has a grievance that his FIR has not been registered by the police station, his first remedy is to approach the Superintendent of Police under Section 154(3) CRPC. Order of the police officer refer to Section 36. If despite of approach the Superintendent of Police or officer referred under Section 36 his grievance still persists, then he can approach the magistrate under Section 156(3) CRPC instead of rushing to the High Court by way of writ petition or a petition under Section 482 CRPC. Moreover, he has further remedy of filing criminal petition under Section 200 CRPC. Why then should writ petition under Section 482 petition to be entertained when there is so many alternative remedies?
Yes.
And next is, Lordship will find 2007 6 SCC 171 para 5.
Yes.
Para 5, Lordship. When any information is laid to the police, but no action in that behalf is taken, the complainant can, under Section 190 related to Section 200 of the Code, lay complaint before the magistrate having jurisdiction to take cognizance of the offence, and the magistrate is required to inquire into the complaint as provided in Chapter 15 of the Code. In case of magistrate, after recording evidence, find prima facie case instead of issuing process to the accused, he is empowered to direct the police personnel to investigate the offence under Section 12 of the Code and to submit a report. If he finds that the complaint does not disclose any offence, to take further action, he is empowered to dismiss the complaint under Section 203 of the Code. In case he finds that the complainant evidence recorded prima facie disclose an offence, he is empowered to take cognizance of the offence and could issue process to the accused. This aspect had been highlighted by this court, All India Institute of Medical Science, Iman. So in this particular case, Lordship will find from the FIR did not disclose any cognizable offence itself. This is a property dispute.
Mm.
And they have not exhausted the remedy. Only filing a complaint before giving a copy to the Superintendent of Police is not help. It should be sent by registered post with ID. By receipt of the letter will not help.
Yes.
Para 7, when any information received by the police about alleged commission of offence, which is cognizable one, there is duty to register FIR. There can be no dispute on that score. The only question whether it can be issued to the police authorities to register the same. Basic question as to what course of adopted if the police does not do it as held by All India Institute of Medical Science, same judgment as followed, reiterated in Gangadhar's case, a remedy available as set out in the above by filing complaint before the magistrate. Though it was finally suggested that there was conflict of views, All India Institute of Medical Science case, Gangadhar's case, Hari Singh's case, we find that view expressed by Ramesh Kumar Singh related action required be taken by the police when the cognizable offence is brought to the notice. Iman. Methodology to be adopted, which is explicitly dealt with All India Institute of Medical Science, Gangadhar Iman. In view expressed by Ramesh Kumar, Lalan Iman, the course available when the police does not carry out the statutory requirement under Section 154, we directly to issue All India Institute of Medical Science, Gangadhar's case, Horizon Kicks Iman, learned the correct position of law, therefore, is that police official ought to register FIR whenever facts brought to the notice to show that cognizable offence has been made out. The case of police will fail to do so, modalities to be adopted are section 190 with section 200 of the code. It appears that the present case, initially the case was tracked, ordered that Iman with WBC case number and subsequently this writ petition are dealing with the aforesaid petition. Writ petition are finally disposed of. Any person aggrieved by inaction of police official to register a FIR, the modalities contained in section 190 reduced to section 200 code are to be adopted and observed. It is open to any person aggrieved by the inaction to the police official to adopt the remedy in terms of the aforesaid provision. So far as non-grant of sanction, it is not necessary. So in this particular case, their procedure is laid down in the code itself for not registering an FIR. They cannot approach the High Court under 236.
Yes. Hmm.
Second also, Lordship 2006 5 SCC 733,
Hmm.
para 4.
Yes.
Same line, Supreme Court reiterated again and again. When any information laid down, information is laid with the police, but no action on that behalf is taken, the complainant can, under section 190, section 200 of the code, by lay complaint before the magistrate having jurisdiction to take cognizance of the offence, and magistrate is required to complain provided chapter 15 of the code. In case magistrate, after recording evidence, finding prima facie case, instead of issuing process to the accused, he is empowered to direct police concerned to investigate the offence, chapter 12 code, and submit a report. If he finds that the complaint does not disclose the offence to take further action, he is empowered to dismiss the complaint under section 202 of the code. In this case, find that complainant evidence recorded prima facie disclose an offence, he is empowered to take cognizance of the offence and will issue process to the accused. This aspect have been highlighted by this court. All India Institute, All India Institute has been relied on. So in this particular case, for inaction of the police, they have approached this court and obtained an interim order.
Yes.
So my submission will be, Lordship, when civil suit is pending, civil suit for the same property, and I have also filed a civil suit, they have also filed a civil suit. And on the basis of High Court's order, Lordship, my suit has been dismissed, rejected under Order 7 Rule 11, and injunction petition also rejected, and injunction was granted in their favor. And High Court order has influenced everything. Now, there is an injunction order passed by the competent civil court. What is it necessary to pass and continue the interim order passed by the Honorable Court? So this is my submission, Lordship.
There is one more judgment you have not read it.
This is, Lordship, All India Institute that has been relied on by all the High Courts, by Supreme Court in subsequent judgment. That is the earlier judgment. There is 96 8 SCC, 96 11 SCC. That has been relied on by subsequent judgment of the Supreme Court.
Okay.
And basically, Lordship will aware that when civil suit is pending between the parties in the same subject matter, there is no question of issuing a writ or interfering at the writ jurisdiction.
Yes.
This is my submission, Lordship.
My lord, first of all, my lord, each case rests on its own facts. So far as the facts of the present case is concerned, my lord, in 2017, an order was passed by judicial court, my lord, affirming my possession up to that land. Despite that order, my lord, they were using martial power. We approached, my lord, police station, thereafter superintendent of police, and we approached, my lord, court also, learned court of chief judicial magistrate. My lord, I have to protect, my lord, my property and my life, because, my lord, so far as disclosing the cognizable offense is concerned, my lord, it discloses. That's why it was not registering. That's why we approached this honorable court. Thereafter, my lord, things are under control, your lordship. Regarding, my lord, injunction order, my lord, injunction order was passed considering the three golden principles: prima facie case, my lord, balance of convenience, my lord, irreparable loss. That was taken into consideration by, my lord, learned trial court. So this case is not in respect of, my lord, deciding the right title of the land. We are here before your lordship because of the inaction and muscle power used by respondents. In fact, in the interim order, this was observed by this honorable court because of the collision with the police. It was done. And, my lord, since the police has not done, so contempt was filed before this honorable court. In contempt, my lord, till today, my lord, he has not filed affidavit. And so far as present writ petition is concerned, in this present writ petition also, no affidavit has been filed on behalf of my lord, state respondent, your lordship. So this is a case, my lord, where my lord, everything cannot be summarized that in this angle because of the facts and circumstances so warranted. That's why this honorable court interfere and pass the interim order, taking into
What do
consideration.
you say regarding the judgments of the?
My lord,
apex court?
judgment was given on the particular facts of that case, your lordship.
No.
Regarding
All judgments are rendered on the facts of each.
my lord, I am coming, your lordship.
But
What
there-
the
there are
judgment is saying, my
principles
lord,
of law which are called.
my lord, alternative remedy, my lord. My lord, there is concept of alternative remedy, additional remedy, my lord. Whether,
Have you gone through the judgments?
my lord, I heard, my lord, when
No, hearing and going through are two different things.
different thing,
You go through it,
my lord,
address us again on Tuesday.
my lord. Not to Tuesday.
And what is the status of the case?
This has been registered.
Why don't you bring it on affidavit?
My lord, I'm relying on what my learned friend has submitted, my lord.
Hmm.
Sarkari Basu, my lord.
Hmm.
This is the principle of law.
Oh, correct. But then why have you not registered the case?
Case has been registered, my lord. I got the instruction, my lord.
What steps have you taken?
It says, my lord,
Any report filed? Nothing.
No affidavit has been filed, my lord. But
No. What is the stage of investigation?
yes, my lord. It says it's under investigation on the basis of the complaints submitted by Sri Kailash Barthakur and Rupam Setia, son of Amuk. Jorhat case has been registered by Jorhat PS case number 3624 under section this and Jorhat PS case number 365. Copies of are here and both the cases are under investigation. If your lordship want to, second page, para 19.
These are your comments. You bring it on record. Why are you showing it to us? Bring it on record if you
My
want. And otherwise, you are supporting the case of the private respondents.
No, my lord, I'm supporting the principle of law, my lord. That is
Right.
Sarkari Basu, my lord. That is the.
Their allegation is not registered.
If your lordship for a time being
Case has
comes
been
to the. If your lordship come to the prayer person, my lord.
Hmm.
Prayer is, my lord, with regard to non-registrant of the affair. Affair has been registered, my lord, and investigation is going on, my lord. Secondly, alternately, to submit a report. Report will be submitted if your lordship directs. Thirdly, my lord, there is to execute a bond. Bond between the parties, my lord. And civil suit is there, my lord, and injunction order is there. Their remedy, if they are agreed by the injunction order, appeal lies, my lord.
Yes.
Can it be taken up on after 5th, my lord? Any date, my lord? 6 or 9, my lord? Or 11, my lord?
No, we are taking it up on a Tuesday or a Thursday. You give us a date.
Thursday.
We have already heard.
My lord, my
But
lord.
only
No, can go.
if the respondents, you bring it on record that the FIR has been lodged. What is the
Yes,
number,
yes,
etc. Bring it
yes.
on record.
And their prayer has been already been,
That is what we want to know.
case has been raised.
Both cases. not
Both
both.
cases.
Let it be on 10th.
10th. Not
10th.
10th, 11, my lord.
11 is not possible.
My lord.
10th,
12, my lord. 12
you'll forget everything.
or 9, my lord. 9.
Is 12th good for you?
Any days lordship.
No,
is
right.
convenient.
12th,
My
Any day
12th
lordship,
of February
lordship convenient.
for further hearing.
interim.
Meanwhile, now there is no issue of interim order. Let us not go
Right.
for that. The respondents will file their, the state respondents.
Settled
have-
SP of the
State respondents going to submit that they have received their instructions. They would like to file their counter affidavit list on 12th for further hearing.
Oblige lordship.
Oblige.
I got to give Mr. Goswami has addressed the court on behalf of the applicant. For further hearing for the opposite party petitioner and the government.
May I submit one thing? Also?
Yes.
So the advocate for the government has stated that case has already registered.
That's right, so we want it on record. Let him bring it on record,
My instruction says, I'm saying.
bring it on record.
Yes, ma'am.
Let it, let there be an affidavit that, and you, if possible, give us the status of the investigation, what is there.
There are two affairs, one paper filed by us, another affair by.
So you say which is registered, which is not registered.
My lord, with regard to item number 4, my lord, I had been requested by my learned friend, Miss Bhattacharjee, my lord, to pass over the case for only for the today. Otherwise, no affidavit also is filed from the Union of India.
She is for the petitioner.
Petitioner, my lord.
On a request made by Ms. M. Bhattacharya, on behalf of M. Bhattacharya, counsel for the petitioner, matter stands before. Yeah, for the, we listed next week.
But I'm paying for a little accommodation for a week, my lord. But here the petitioner number 4 has expired, my lord. We are taking steps for substituting him, my lord. That we have indicated to your lordships on last occasion, my lord.
Petitioner number?
4.
Oh. Mr. R. Dubey for the petitioner, you are for the petitioner.
Yes, I am for the case.
It is submitted that the petitioner number 4 is expired and accordingly steps are required to be taken for bringing on record the legal heirs. Matter therefore be listed after 4 weeks.
There is an interim order that needs to be completed.
Interim order are passed earlier, if any, will continue. Then you matter be listed on 13th.
My lord, shorter date.
13th.
Item 6.
Lordship, I am the custodian of the elephant, my lord, Kongamala, my lord. This elephant was, my lord, taken the
What has happened here? What?
Well,
Lordship,
they purportedly they owned an elephant madams. The elephant was sick. They transferred the elephant from Kachar to Tinsukia to a particular person of the Moran community, my lord, who specializes in treating the elephants. Though it's camouflage, now what has happened, my lords, other aspects, my lords, when the elephant was there, my lords, another person from Arunachal also claimed that I am the owner of this elephant. And the elephant is under the seizure of the Arunachal authorities now. But what has come to light in this during these proceedings, my lords, there was a sale, which is totally prohibited, my lords. There was a sale entered between by the petitioner and the respondent number 7 in the petition, my lords.
Sale of the
Elephant, my lords. We have filed an affidavit, my lords. They have notarized agreements. They have
we denied, my lord.
then
Lordship,
and now the elephant is in the custody of Arunachal, my lords. For proper of this case, my lords, proper scrutiny of this case, my lords, Arunachal has to be implemented as a party, my lords. Because lordship will see section 43 of the Wildlife Act, my lords. It completely bars any kind of commercial transaction.
But my lord, the stand of the DFO is that, you know, the elephant is the custody of the DFO, my lord. And my lord, Annexure 10 may be seen, Annexure 10 and Annexure 11 of the writ petition, my lord.
Wildlife Protection Act 1972.
Page 34, my lord, and page 35, my lord. This letter was issued by the Principal Chief Conservator of Forest, my lord, to the DFO, Dumduma Forest Division, my lord. Regarding transfer of female captive elephant named Gongamala from Kakopatar, Tinshukia to Ganganagar, Silchar, Assam, my lord. In view of the verification report submitted by the Chief Conservator of Forest, Southern Assam Circle, and upon receipt of the satisfactory health status report from the Divisional Forest Officer Dumduma Division in respect of the female captive elephant named Kongamala,
issued by certificate of ownership number such and such, date and such to the Haji Mahmood Ali Majumdar, page 34, my lord. Which was transferred from Ganganagar, Silchar to Kakopata, Tinsukia under extreme emergency
So
situation.
they cannot be sold.
But our affidavit, my lord, will see. There are money receipts. Actually, to the tune of 11 lakhs. The affidavit in opposition
No,
filed by.
how will the elephant be purchased?
Exactly, my lords. They cannot be, it is illegal, my lords. Now it has come to the surface. We have been scrutinizing these things, my lords. And in the meantime, the new dispute has come that Arunachal is, another person from Arunachal is claiming that it is his lost elephant. So state of Arunachal has to be implemented, my lord. Lordship will see page annexure A, page 61 of the affidavit in opposition. It's the petitioner, my lord, Nurul Haq Laskar. And then, lordship, there is a stamp, e-stamp, brought by, again, Nurul Haq Laskar. He is giving to Gupendra Moran, who is respondent number 7. I have been informed, my lord, this elephant is on the verge of giving birth, my lord. It's in the custody of the Arunachal authorities. It's not that we are not saying that you don't take it. We have been informing them, you take it, take the elephant.
Where is your certificate of ownership?
They don't have, my lord. They're acting on a power of attorney.
Lordship, certificate of ownership in page 23, my lord.
Page 20.
Page 23, my lord, in my writ petition, my lord.
No.
Muhammad Ali Majumdar, my lord.
No, Haji
Name of
Mohammed
the
Ali.
custodian, my lord. He is the Mahmood Ali Majumdar is the owner, my lord, and I am the custodian, my lord. Custodian certificate is page 22, my lord.
Who has issued this certificate?
Range Forest Officer, my lord. Sunaika, sir. Moniar Khal Nunaika, sir.
The original, my lord, it's page 24, which concerns us, my lord. Page 24, it's the exact statutory form, my lord. It's in the name of some Haji Muhammad Ali Majumdar. Then he gives to one Fakhrul, and then Mr. Fakhrul gives it to this present petition. Do you know what? And at page 70 of our affidavit in opposition, also will find the respondent 7. He has given a statement. Let's translate copy.
Statement is page 49, my lord, in my additional affidavit, my lord. Running page 49. There is no statement regarding any sale, my lord. Statement of the respondent, my lord.
No, how did you come to possess? How did you possess the elephant?
Lordship, by means of power of attorney, my
Where
lord.
is that power of attorney?
Power of attorney, my lord, page 26, my lord.
No. Page 18, my lord, regarding
Page
this case.
26 and
The petitioner, page 18, my lord.
This is with Fakhrul Islam Borbuya.
Yes, my lord.
Who are you?
And
Fakrul gives to him.
Huh?
Fakrul gives to me, my lord, in page 18, my lord. Special power of attorney, my lord.
How can he give it? How can an attorney holder further delegate? Hey, you have made a wrong statement here. Fakhrul Ali is claiming to be the lawful owner. You're not the owner. He's not the owner.
I'm not the owner, my lord. I am the custodian.
Come to page number 18.
Shit.
Fakhrul Islam Barbuya
Yes, ma'am.
is a lawful owner. He's not the owner. He was the first attorney holder.
Yes, my lord.
Then that's a wrong statement. So attorney holder can further delegate to another attorney holder without the consent of the owner. Hmm. What is your prayer? Prayer here?
Prayer, my lord, the lordship responded not complied, my lord, with the direction of the
Where is the direction?
principal chief conservator of forest, my lord. Direction is page 34 and 35, my lord.
So why is the Dimduma DFO not releasing it?
Well, this elephant has been taken into custody by Arunachal authorities, my lord. So another person has claimed this elephant to be his elephant, which was lost way back in 90s.
He is from Arunachal Pradesh.
Yes, my lord. The other person is from Arunachal.
So where have you stated that?
Look, our affidavit, my lord. Paragraph 11, my lord. Not only 11, my lord, so see, not para 11, paragraphs. Annexure D, page 69. Should be. Lordship, that is paragraph 7. The DFO Namsai Forest Division has written back. One person, he says this elephant was lost in 1987.
And Annexure 9, my lord, in repetition, my lord, DFO himself reported, my lord, Gongamala is under custody of Dumduma Forest Division, my lord.
Then you have to array the Arunachal.
They have to array Arunachal, my lord.
Without their information, how to get the correct information, whether they are available or not. The DFO Dumduma says it has been taken away by Namsai and they have not released it.
And the letter says, my lord, he is under the custody of the.
But he has filed an
After
affidavit.
that, these developments are after that.
He has filed an affidavit. You see his affidavit, statement in the affidavit. Affidavit is very clear that some complaint was received by another person. And it was seized, detained by the forest authorities of Arunachal Pradesh.
Worship, without any interstate transit pass, my lord, how can this?
I don't know, this is what the government is.
No, my lord, interstate pass will come to play when it's the elephant is transferred from state to state. Now, Arunachal authorities say it is their elephant. Somebody has raised another counterclaim. To adjudicate, my lord's letter is very clear. To adjudicate, that is been
And
taken. into
you have
custody.
not also arraigned this Gupendra Moran as a.
He's
party.
arraigned, my lords.
He's arraigned.
Arraigned.
Who is appearing on his behalf?
Nobody appears, my lord.
Have you served, how have you served notices?
Yes, my lord, notice was duly served, my lord.
How?
Worship, by order dated, my lord, kindly say, Lamajima order dated 17/7/2025 and Honorable Court order dated 18/7/2025, my lord. The Honorable Court confirmed the service, my lord.
Let the DFO also file a report here. Let him file a report. When was it in his custody? When was it?
My lord, it was given to, since that respondent number 7 is a specialist in treating elephants. Since the elephant was admittedly sick, and it was the very purpose it was transferred there, it was given into interim custody to the respondent 7.
That's right. But
I'll file.
at para 7, you said
Yes.
some dispute arose, and on what is the basis of this information?
There's a communication, my lord.
What steps have they taken?
There's a communication, lords will find at page 69. The Arunachal Pradesh Forest Authorities write to us.
69.
69. Annex D. So this Arunachal Pradesh has to be impeded, my lord, because it speaks of some investigation. What is going in their state of affairs?
Third counsel for parties, the petitioner before this court is seeking orders from this court to the respondent forest department for release of the elephant given by the name Gongamala, which was stated to be in the custody of the DFO Dumduma. Stop. The elephant suffered a fracture and was accordingly taken by the petitioner for treatment by respondent 7, who is stated to be a person specially who is having special knowledge about treatment of elephants through naturopathy. So, during the period when the elephant was in the custody of respondent 7, a claim was raised by another person from the state of Arunachal that this elephant belongs to that person, and it was lost in the year 1973.
1997.
Huh?
1997.
1997. And in view of this dispute, the elephant has been kept in the custody by the Arunachal forest authorities. So, the DFO Dumduma Forest Division has already filed an affidavit making the said averments. So, The Arunachal Pradesh Forest Department is not arrayed as a party. Under such circumstances, we direct the DFO, Tumduma, to furnish a complete status report with regard to the said elephant, Gongamala, which was stated to be in his custody and subsequently thereafter in the custody of the Arunachal Forest Department stop. The petitioner is also at liberty to array the government of Arunachal Pradesh, Department of Forest, if so advised in the meantime. Let this status report be filed within 3 weeks. List accordingly.
Published.
Date will be from.
27th of February.
May I please? In item number, my senior is on, my senior is on lakes. Matter may take up on Tuesday for final list.
What is the matter about?
Well, its matter is about, well, it's, item number 7, my lords. Matter is about issue related to labor cess, my lords. And in light of the Supreme Court judgment, my lords, we file a writ petition that any deduction on the labor and supply is not been deducted as by statute, my lord, under the provision of BOCW Act. So, my lords, under this writ petition, my lords, arguments already been done, and I placed a number of judgments, my lords, in support of this.
Arguments done before, not before this court.
My lords. My lords.
Was it heard in part?
My lords, on the previous. So, my lords, on the previous occasion, my lords, direction was being given to the department to file an affidavit that whether there is a question of construction activity was being involved in this tender. Since, my lords, my objection is about that as per this tender, my lords, my scope of service is confined to supply and such. My lords.
By which order was this direction given?
My lords, on the very last, apologies, my lords.
Last order is
Last
order is merely to list the matter on a particular date.
So much there was an oral observation given by the lordship.
No, it's not recorded in the order sheet.
Yes.
Anyway, the pleadings are complete.
Pleadings are complete.
No, no. Then there is a prayer on behalf of the respondent counsel to take up the matter on some other date. When do you want it?
Tuesday, my lord. No problem.
Tuesday. All right. On 3rd.
Yes, Lord.
On 3rd.
Much of it.
On the prayer made by the counsel for the respondent, list this matter on 3rd of February. Mr. Goyal.
Very good.
He appears for the writ petitioner.
B dash for the department. APDCL.
Which department?
APDCL.
Mr. B dash appears for the APDCL department.
Much obliged.
Supplementary list for admission, I think, 23 and 24.
May I please, Your Lordship? It's a supplementary matter.
Yes.
Yes, madam. Now, these are income tax petitions, red petitions. And one of the ground is covered by a lordship's judgment, which is on the issue of Jao Fao. The notices have been issued by the jurisdictional officer instead of through faceless mechanism in compliance of the CBDT circular. It's the same issue.
You're referring to Ram Narayan Shah?
Yes, madam. That's right.
What
One of this.
Yes, Lordship, otherwise matter is covered by this judgment, my lord, your Lordship has declared. My lord, in many high courts, my lord, they have decided the issues in favor of the SSE. And my lord, Gujarat High Court has decided in favor of the department. Now, my lord, matter has went to the apex court. My lord, instructions is awaited, my lord, as to the, my lord, outcome of the, my lord, the decision taken by the apex court. May I?
The matters remain pending in the apex court. There is no decision as such. So the entire
Otherwise,
litigation.
yes, your lordship has passed this order, my lord, that will cover this case also, my lord, as notices were issued by the, my lord, jurisdictional assessing officer. My,
And what is the order of the Madras High Court? Judgment of the Madras High Court? That it can be done.
lordship, Gujarat High Court has said, my lord, that it can be issued by the jurisdictional assessing officer also.
No, which matter travel to the apex court?
That is, my lord, the issue is, my instruction is, my lord, that present issue, my lord, whether notice can be
No,
issued
from
by,
which High Court?
my lord, that too, my lord, I have to sort this. Take it.
Plus, it is, plus Bombay High Court has also traveled to the Supreme Court.
Right.
And even Delhi High Court, and from all other high courts, the matter has traveled to the Supreme Court. It's a,
Well, I think
the issue.
we should
which-
await for the outcome since so many matters have traveled
Lord,
to the apex
Lord.
court.
Very well.
When is the next date? When is the next date of hearing likely?
In the Supreme Court, minutes, I need to check.
Yes. All right.
Supreme Court में date.
Heard counsel for the parties. This matter pertains to initiation of faceless assessments. Sorry, initiation of proceedings under section 148 by the department, by the jurisdictional officer. Stop. The counsel for the petitioner has projected that in terms of the notification issued by the CBDT, all these proceedings are to be undertaken through the faceless mechanism. Stop. A judgment rendered by this court in Ram Narayan Shah, reported in so and so, has also been pressed into service in support of the contention. It is submitted that this matter stands covered by this judgment rendered by this bench. Stop. Counsel for the respondent, Mr. Setia, on the other end submits that there are several judgments passed by several high courts. There are judgments passed by other high courts, and some of the judgments have traveled to the apex court, and the matters are pending there. Stop. The counsel for the parties are permitted to apprise the court on the next day as to the status of the matters pending before the apex court regarding this particular issue. Accordingly, list again after 4 weeks. Please tell us what is the status.
Lord.
Very well. Interim to continue.
Interim orders passed or we will continue.
Very well.
Yes, Lord.
Okay.
Daily list for hearing item 9.
May I please your lordship, Mr. Sharma is legs before another court lordship. May I kindly pass over the matter for the time being.
Time being.
Much obliged, lordship.
Items 10 to 12.
My lord, item 10, my senior legs in another court, kindly pass over for time. Take a fix.
What are these matters?
Regarding land grabbing matter. So there are the law is that civil liability shall be decided first and there are the criminal liability. Now that I think that is not proper, though the procedure laid down in section 10, but here the question says that civil liability prima facie has not proved. But our case is that when the land has been grabbed by a group of people and admittedly land belongs to me and I have purchased, so long civil liability if decided fast, it will take long time. And criminal liability, if it is taken up for disposal, then my lord, eviction order cannot be passed in civil case, in a criminal case. So our submission was that it should be under the provision of section 356 of Land Grabbing Act. So that prima facie proof, it is the burden of duty lies upon the accused person. But here, if that is done, it will take long time, my lord.
No, no, we'll take it up in the second half.
In item number 10, Lordship, we require more time, Lordship.
Huh?
In item number 10, I am appearing on behalf of Revenue and Disaster Management Department. Would you require more time, Lordship?
Item 10,
Yes, Lordship.
you are representing whom?
Revenue and Disaster Management Department, Lordship.
May I please, my lord?
We have to obtain instruction regarding the constitution of appellate tribunal, Lordship.
That is more than 3 years they are taking this instruction, more than 3 years. It
Well,
is
yes.
not yet constituted, so far we are concerned.
Yes.
May I please? You know, in item number 10, I'm appearing for on behalf of the respondents 4 through 12.
Hmm.
And I have already submitted my written reply also as regards to the petition, read petition. My lord, the only point to be considered, whether the read petition is maintainable against the judgment passed by the special tribunal court sitting under the Land Grabbing Act.
Is there any appellate forum?
No.
Appellate forum, my lord, what yet formed on the last occasion, it was submitted that the government is going to consider regarding the formation of the appellate court.
So within the
But-
absence of any
But
appellate
it-
forum,
My lord, that
where
whether
will they
this,
go?
my lord, that this honorable court sitting under read jurisdiction
Hmm.
can consider anything, whatever passed in way of the judgment. At best, they could have filed a petition under 226 or any other
227.
forum. If
This is a petition under 226 only.
This is judgment passed by this court, Mr.
Yes.
This each court have no business.
Yes, my lord, I have also got one judgment.
Right.
Yes, my lord.
You give another copy to the court master. You give the citation to the court master, take a printout. We'll come back at 2. Copy it on the does it. Yes. There appears to be some.
Yes, sir. In this case, it was without converted into 227. That's true.
Hmm.
Now, the other issue is that the appellate last time submission was being made that the appellate for tribunal, there's some process on.
Need some time.
2 weeks. All right. Third counsel for parties, MSG Hazarika, learned counsel for revenue. Submits that the process of establishment of an appellate tribunal to decide orders passed by the competent court under the by the special tribunal under the Assam Land Grabbing Prohibition Act 2010 is underway. However, present status is not known to the council. She prays for 2 weeks' time to complete her instructions. So it is submitted that once the tribunal is established, all these matters can be transferred to the tribunal for an effective decision in the matter. List again after 2 weeks.
This thing they are saying since last several years, my lord.
Several years.
It is 2016 case, my item 11, 9 years pending. It is already under 227.
List on 20 February. Please get positive instructions, otherwise we'll proceed to decide.
My lord.
Now, in the judgment of the coordinate bench, it had treated an order to be an order of a civil court.
Civil court.
There is no appeal against this judgment.
No, my lord. My lord, in fact, the party was, he was, my lord, was not financially in a position to, my lord, he said, I'll not challenge it.
But
Whatever it
there is no provision for filing a first appeal.
No provision, my lord. The provision is in the, if the appellate tribunal comes,
Tribunal.
yes, my lord.
Appellate tribunal.
Otherwise, 227, my lord, dictates limited, my lord. That's the difficulty, my lord. And it's
Mhm.
it's well, substantive rights are involved, my lord, of the property. Therefore, my lord, 227 things get limited, my lord. Scope is very limited, my lord. It's a problem.
There is another judgment of this High Court in respect of a matter passed in Arunachal regarding election tribunal. There was no election tribunal, matters were filed before the High Court. Court held that it was competent to decide.
Here also, my earlier 226 and 227 both were being entertained. Whoever filed on 226 was taken up on 226, and whoever had filed on 227 was taken on 227. But this judgment, my lord, this honorable court said, my lord, that it will be 227, my lord.
That's the one thing. When a section comes, then matter may be disposed of.
On the basis of the instructions that may be furnished to the government council, attempt will be made to dispose of all the writ petitions. Let's take order.
In nine.
Waiting for a petitioner. Lordship.
Start from sound.
Yeah.
The petitioner is aggrieved by an order passed by the banking ombudsman, your lordship. Main grievances against the illegal interest charged on cash credit facility by the bank, and also illegally charged commission in bank guarantee, your lordship.
When is that order of the
Banking ombudsman, your lordship?
ombudsman?
Wait, 156, your lordship. This is the type copy, your lordship. Main order is, please refer to your complaint dated so and so and your acknowledgement mail dated so and so on the caption subject. In this connection, it has been observed that there is no deficiency of service in regard to asking panel charges at 2% by Axis Bank. However, the subject matter of grievance pertains to bank guarantee, which does not fall under the purview of banking ombudsman scheme. Therefore, banking ombudsman decided to close the case under clause so and so, read with clause.
No,
8.
where is the banking ombudsman's order? Ombudsman's order.
This is the order.
This is the order.
Yes, non-speaking order.
Huh?
Yes, as page 157 is the. I have an extra type copy at the page 156, your lordship. That's real number 2, the rejection of complaint under provision of clause 13A of the banking ombudsman scheme is non-appealable. However, you are free to approach any other forum for redressal of your grievances.
Where is that scheme? Ombudsman scheme?
Yes, banking ombudsman scheme. Alright. हमने तो मार्क किया था, वो चला गया क्या? मार्क किया और चला गया क्या? Clause 13 is relevant, your lordship. It was rejected under 13A, your lordship. Rejection of the complaint. The banking ombudsman may reject a complaint at any stage if it appears to him that the complaint made is not on the grounds of complaint referred to in clause 8
or otherwise not in accordance with subclause 3 of clause 9. Now, if your lordship comes to clause 8, the grounds of complaint are given, your lordship, at clause 8.1.
Hmm?
Clause 8.1, the
Hmm.
grounds of complaint were given, your lordship.
So under what laws do you base your complaint on?
Yes, your lordship. Uh, our main grievance is imposition of interest illegally on prepayment of the CC account. That is our main grievance, your lordship.
No, some bank guarantee was.
Yes, bank guarantee is also there.
Hmm.
There are two grievances as reflected from the order itself. Under 8K.
8
1K.
K.
Hmm.
Levy of charges.
Yes, without adequate prior notice to the customer. That is number 1.
Hmm.
And then they have also violated the master circular of RBI, which come under R, non-adherence of the fair practice code as adopted by the bank. This because they have violated clause 2.5.2 of the master circular of RBI, which speaks about fair practice. These are the two. So we fall under these two. But
Where is the master circular?
Sorry, copy. Complaint like attack any complaint like attack.
Why it is not brought on the record? Should bring this on record, relevant documents.
The guidelines. You can file an
Which clause is violative?
2.5.2. Loan application B, Roman 1A. Small a. Loan application forms in respect of all categories of loan, irrespective of the amount of loan sought by the borrower, should be comprehensive. With a view to bringing in fairness and transparency, banks are advised that they must transparently disclose to the borrower all information about fees, charges payable for processing of loan application, the amount of fees refundable if loan amount is not sanctioned, prepayment option and charges, if any, penalty for delayed repayments, if any, conversion charges for switching loan from fixed to floating rates or vice versa, existence of any interest reset clause, and any other matter which affects the interest of the borrower. Such information should also be displayed on the website of the banks for all categories of loan products. It has come to our notice that some banks levy, in addition to processing fees, certain charges which are not initially disclosed to the borrower. It may be mentioned that levying such charges subsequently without disclosing the same to the borrower is an unfair practice. And I have shown at 2R, against unfair practice, we have a right to file complaint, Your Lordship. And they have not disclosed it at the initial
But
sanction.
this is with regard to loan.
At CC account is loan, Your Lordship. I am agreed by two. Firstly, I am agreed by the prepayment charges levied on my loan account. This circular covers that any prepayment charge, if they have to levy, they have to inform us initially. And they will also have to publish it in their official website. They have done none of these two, Your
But
Lordship.
it must be a part of the loan agreement.
No, it is not.
Loan
Initially,
agreement will indicate when the
No.
charges will be there. or
no,
not.
initially the loan was sanctioned for 1 year.
Hmm.
That was the initial sanction. Nothing was mentioned there regarding prepayment. Then subsequently it kept on renewing. Only on the 4th time when it was renewed, they have inserted that clause. But RBI says that from the very initial stage itself, when the loan was disbursed, they will have to give us prior notice of any prepayment charges or interest that they want to levy on the loan account. This is what 2.5.2 says, Your Lordship. And if
Then-
Your Lordship may permit me to come to the facts, Your Lordship will be.
Yes.
Yes. So now initial sanction, Your Lordship.
Hmm.
At page 46, Your Lordship.
Hmm.
So this is, I have given a type copy, Your Lordship. Also annex the main copy. Your Lordship. So initially, Your Lordship will find at page 46, Roman 1, cash credit 12.5. I'll come to bank guarantee later. This is 12.5 crore.
Hmm.
This is the cash credit, which is a loan. At page 47,
Hmm.
A, nature of facility cash credit. This is the loan. Limit, rupees 12.5 crore. So we have a loan of 12.5 crore, sanction loan. Now within bracket, this is important. By way of takeover with enhancement in the existing CC limit of 7.5 crore with SBI. So what happened, Your Lordship? Initially, my cash credit account was with SBI. And thereafter, it was taken over by Axis Bank. And when they took over, no prepayment charge was imposed upon us by SBI. Nothing. They simply took over the loan from SBI. Now, this is valid for 12 months, Your Lordship. And it is renewable after every 12 months, Your Lordship. And at page 49, Your Lordship will find. Validity of limit repayment, C, page 49. Validity is 12 months. Repayment is payable on demand. So whenever they demand, I'll have to repay. Now, the nature of the cash credit loan facility is such that from the initial day when it was sanctioned, for 12 months, there will be a 12.5 crore sanction amount for me to withdraw from them. I can withdraw 12.5 crore at a single time or at multiple times. And as and when I withdraw money from the account, that will be considered as a loan and the interest will be levied on that. So suppose, for instance, if I withdraw 5 crore initially, then and I can repay it in installment like 1 crore for 5 times and another installment for the remaining interest, then the debit balance will automatically become 0. They don't charge any amount on that. And regarding this statement of mine in the writ petition, in my pleading, Your Lordship, they have admitted in their reply, Your Lordship. This will clarify the position at paragraph 12 of the writ petition. At paragraph 12 of the writ petition, Your Lordship.
Now, tell me one thing. Where
Yes.
is this? Where is that order of the ombudsman? It is what you are showing us is a communication.
That is the order, Your Lordship. That is the imping order, Your Lordship. Non-speaking order, Your Lordship.
There is no
Huh?
Only one sentence, there is no deficiency of service. That is the order, Your Lordship. Page 150. Please refer to your complaint dated so and so. We have filed a complaint and this is the order passed. And at 157, Your Lordship may kindly come to page 157. At 2, it will clarify that this is the order. The rejection of complaint under provision of clause so and so is non-applicable. However, you are free to approach any other forum. So they have rejected and they have stated that it is non-applicable and we can approach any other forum. This is their order, Your Lordships. In the complaint petition, I have taken all the grounds, but by way of a non-speaking order, they have said that only there is deficiency of service.
Why does it say that it is not appealable?
As for banking ombudsman scheme that I have furnished, Your Lordship.
No, there is
Clause-
an appeal provision at clause 14.
Not 13A, Your Lord. It is rejected under 13A. That is why it is not applicable.
No. You look into 14.
Yes, 14. Any person aggrieved by an award under clause 12 or rejection of the complaint for the reasons referred to in subclause D to F of clause 13, and it was rejected under clause 13A. That is why it is not applicable. Had it been rejected under any of the clause of D, E, or F, then it would have been 2006. Then it would have been applicable. Your Honor. But the rejection was made under 13A.
Your Lordship, the matter may be taken upon some other days because I have to go through this banking ombudsman scheme. And this, I think, the point that has been decided, the scheme which I have, I do
Mentioned
not.
it in the, before even we started.
Paper which I have, we do not have these points.
I can file a small additional affidavit also, or I can furnish the copy as.
What?
To
This
bring this on record, or I can.
Because on every
Because
year,
things
it is
can
going
act,
to be
Your
changed,
Lordship.
Your Lordship. So which scheme they are
It
referring?
is for you to decide. You are the banking authority.
Yes, sir.
Relevant ombudsman, banking ombudsman notification, you get it.
Yes.
This is 2006.
2006, yes, Your Lordship.
And when is your case?
It's mentioned in the order also. The banking ombudsman scheme 2006.
It is the main scheme. The main scheme.
It is the main scheme. That is under this scheme only it was rejected.
There is no dispute on that.
Yes, Your Lordship.
Scheme.
When do you want it?
When do you want it? The court is asking.
Your Lordship, within 1 week may be given.
Next week. होगा नहीं बोल रहे. Next week हम लोग क्या प्रॉब्लम है?
इसका कॉपी देंगे.
हाँ, मन से कॉपी बना के दे. ये तो ऑनलाइन ही मिल जाता है. ठीक है, दे दो. PDF कॉपी आपको व्हाट्सएप कर देगा मनीष की.
व्हाट्सएप कर. व्हाट्सएप कर.
The reason for rejection of the complaint is non-deficiency of service.
Not.
That is not one of the ground under section 13 or clause 13.
Prepayment was covered under this. No, basically, Your Lordship, they are coming that regarding the prepayment charges we have imposed upon.
That's right.
Yes.
So this was rejected on the ground that there was no deficiency in service.
Yes, Your Honor.
That
Huh?
has been decided by the ombudsman that imposition is not deficiency.
No. Clause 13 talks about rejection.
Yes.
Yes.
Then A, B, C are grounds on which there is no appeal.
Yes.
Yes, sir.
If it is D onwards,
Yes.
D, E, F, then there is an appellate forum.
Yes, sir.
Now, non-deficiency of service falls under which clause? According to the bank, it falls under A, B, and C, but there is no specific indication. A, if you see, not on the grounds of the complaint referred to so and so, and otherwise not in accordance with clause so and so. Then beyond pecuniary jurisdiction, this is not the ground.
No.
Requiring consideration of elaborate documentary oral evidence. This is also not the ground.
No, Your Honor.
So one will have to presume it is clause A.
A.
So clause A talks about is not on the grounds of the complaint referred to in clause 8
Or otherwise.
or otherwise not in accordance with clause 3 of 9.
Yes.
So clause 3 of 9 is not applicable.
Not applicable. So remains only clause 8.
You examine this and tell us.
Yes, sir. Yes, sir.
Only request made by the counsel for the respondent. Matter stands deferred. Let the matter be listed again after 1 week. On 19th.
Yes, sir.
19th of
कब से ये बोल रहे थे? Not, बोल 320. Can it be on 23rd or 24th, you know?
23rd, 24th, then 26th. 26th.
Sorry, 26th. Okay.
It's not 26th.
Obliged. I'll let the ombudsman. I mean, why is he missing?
May it please your lordship. Lordship, in this matter, before I proceed, if your lordship peruses the order dated 16/9/2025, the original records approved by the ministry, that is the Ministry of Road Transport and Highways, was called for.
16/9.
Yes, 16/9 order. The original records were called for, lordship. In this matter, I am basically aggrieved by taking over of my land without following the due process of law, lordship.
May it please your lordship. Lordship, the petitioners have filed their additional affidavit on 6/1/2026, lordship, and we want to take instruction on that.
This is 29. We are on 29 today.
Yes, lordship, but instruction, lordship, there they
Who is to produce the records?
lordship records.
Records were initially, NHIDCL were directed. Subsequent date, the council for NHIDCL came and informed the court that the records are with the autonomous council, lordship.
Lordship, 2 weeks will file the reply to the affidavit, additional affidavit, lordship.
And he'll also produce the records.
Yes.
Yes, the records that is approved by the ministry, specifically stated in that 16/9 order.
All right, heard counsel for parties on the request made by MS
As compared, lordship.
S. Kemprai, standing counsel, appearing on behalf of KAAC. Submits that they would like to complete their instructions on the additional affidavit filed by the writ petitioner. So the counsel for the petitioner, Mr. Chaudhary, also draws the attention of the court to order dated 16/9/2025, whereby a specific direction was issued to produce the records containing the map which is approved by the Ministry of Surface Transport.
Ministry of Road Transport and Highways.
Road Transport and
Highways.
So
4 or 5 dates have gone after this. They have not yet produced the record, lordship.
So accordingly, list again on 26th of February. The respondents will produce the records as directed by this court by the order dated 16/9/25.
Yes, lord. Yes.
Yes, Mr. Talukdar for NHIDC.
That's
Obliged.
May it please your lordship. Lordship, in this matter, we're seeking for accommodation, your lordship, as the engaged counsel, Mr. K. Chaudhary, is unwell today, your lordship. Lordship, we've informed the respondents, your lordship.
Yes, Mr. Mazumdar.
It is unwell.
The prayer is made on behalf of Mr. K. Chaudhary, who is the counsel for the petitioner, who is stated to be unwell. Therefore, adjournment is sought for on his behalf for how much time?
2 weeks, lordship.
We have agreed on a date on 19th.
19th.
Subject to your lordships.
All right, Mr. D. Mazumdar, learned additional AG, appears for the state, is agreed to by both parties. Lists matter again on 19th.
Lordship, there's an interim order.